Welcome everyone. We will wait just a couple of more minutes until noon to allow more attendees to log on, and then we'll start the presentation. Okay, it's 12 o'clock, so we will begin. Welcome everyone to today's CLE. We have Byron Conway, an assistant federal defender, discussing the power and persuasiveness of storytelling and opening statements. Throughout this presentation, feel free to use the Q&A feature. We'll keep an eye on that. You can also raise your hand and we will unmute you if you prefer to ask your question instead of typing it into the Q&A. Let's see, we'll leave a little bit of time at the end as well. If you prefer to ask your questions after the presentation has concluded, that'll be okay. So I will introduce Mr. Conway and then we'll turn the time over to him. Byron Conway Jr. is a criminal defense attorney with a passion for advocating for the most marginalized in our society, those who are often unheard, disregarded, and disrespected by a system that every day fails to see their basic humanity. Byron's passion for the work he does comes from the environment he grew up in. The clients who Byron works so hard to zealously advocate for are more than just bodies to him. In every client he has, Byron sees his family members, his friends, his community, and he knows that many times these individuals have never had anyone really fight for them or tell their story. The front line of the fight for justice and equality requires dedicated soldiers, and Byron is proud to count himself one among them. Byron was born and raised in the inner city of Detroit, Michigan. He graduated from Charles F. Kettering High School in Detroit and matriculated through the University of Michigan in Ann Arbor on a full academic scholarship. Byron graduated U of M with a bachelor's degree in political science and African American studies, with a particular focus on African American political ideology. After graduating from U of M in 2010, Byron attended Boston University School of Law. Byron graduated from Boston University School of Law with honors in 2013. After graduating law school, Byron joined the Public Defender Service for the District of Columbia, PDS, as a staff attorney in the trial division. Byron's practice primarily focused on defending indigent individuals charged with serious felony offenses in the District of Columbia Superior Court. While at PDS, Byron was one of the charter members of the organization's mental health practice group, which specialized in litigating at the intersection of mental health and criminal culpability. After several years of working with the most amazing people at PDS, Byron transitioned from his role in DC in May of 2019 to Atlanta, Georgia, where he is currently an assistant federal defender with the Federal Defender Program. In his current role, Byron defends indigent individuals charged with felony matters in the United States District Court for the Northern District of Georgia and handles appeals before the United States 11th Circuit Court of Appeals. In addition to actively trying cases of his own, Byron is a nationally sought-after trial skill trainer for various offices throughout the United States. Byron also currently serves as a faculty member for the National Criminal Defense College as well as a member of the Board of Directors and the chair of the Federal Defense Practice Section for the Black Public Defender Association. We're happy to have him here presenting to us today, and I'll turn the time over to Mr. Conway.
Good afternoon, everyone. Thank you, Genevieve, for that. I appreciate it. It's always weird to hear someone else talk about you, and it's just weird. But I'm so happy to be here today. I'm so happy to come to you and talk to you about something I love, which is trial practice and specifically opening statements. I would be remiss if I didn't give a shout out to Ben Miller, who actually invited me to speak with you all today. But one thing I want to talk to you about is storytelling and opening statements. A lot of the times we think of opening statements as fairly formulaic. There's rules that we have to follow and there's parameters we have to stay within, and we can't do certain things and otherwise we're going to get objected to. But the one thing we can do effectively in opening statements is tell a story. What is your client's story of innocence? What is your client's story of not guilt? What is your client's story of reduced culpability? Whatever your theory of the case is, what is the narrative that is going to empower the jury to act on your client's behalf? So let's start here. I want you to take a look at Kevin. Kevin is 26 years old. He lives in Los Angeles. He's a construction worker. This is Brenda. Brenda's 29, an office manager, lives in Los Angeles as well. On one evening, Kevin was going to the store to buy food. Kevin had no food in the house, so he figured he would stop by the store on his way home. Unfortunately for Kevin, while he was in the store got held up. Kevin was shot during that experience, and he unfortunately lost his life. Brenda is hungry, and she's crying incessantly, and there's nothing that anyone can do to console her. Let me ask you all a question, and this is not a rhetorical question, so I actually want somebody to answer, and it could be the absolutely wrong answer. I don't care if it's the right answer or not. Why is Brenda crying? Anybody?
All right, here we go. She has a child she can't feed. And there was a hand raised, but I think it went away.
Okay.
Oh, and she was related to Kevin is another response.
Interesting. Okay, she has a child she can't feed and she was related to Kevin. Okay. Any other responses as to why Brenda may be crying?
She was a witness.
She was a witness. So we have three very different plausible answers to why Brenda may be crying, right? Either she knew Kevin, she was related to him in some way, she had a child she can't feed, or she might have been a witness to the unfortunate loss of life of Kevin. The problem that we have with the story that I just gave you, the narrative that I just gave you, is that we don't have enough facts. We don't have enough information to know why Brenda is crying. I never told you that Brenda or Kevin were related to each other. I never told you that Brenda knew Kevin. I never told you why Kevin went to the store, and I never told you whether his going to the store was related to Brenda being hungry. And herein lies the problem when we don't craft a story, a narrative of our client's version of events to the jury. The jury just begins making up their own story. So all three of those things, while quite plausible and quite reasonable to think about, those were your brains filling in the information that you evidently did not get from me. And that's what our brains do. Our brains are predisposed to walk through the world in story form. Another example. What do people see when they see this image? Anybody? What are you seeing when you see this image?
Fear.
Fear, yes, fear. What else? How about we see someone bigger chasing someone smaller? We see one person scared and the other person angry. Now, what if I told you that in fact what you're seeing is the same thing? The people, the monsters in this photo are actually the exact same size, and they're running from the exact same thing, but they're not running from each other. The reason that they look different is simply because of where they're placed at the time within the tunnel. But without any of the backstory as to any of this, we develop a story to help us make sense of the image that we're perceiving. And that's why storytelling is so important with what we do within our trial presentations. Because if we don't give them the story, the jury will make one up. And the story that they make up may not necessarily be in line with what you want them to be thinking about when they're deliberating your case. And so when I think about stories, I think about Sophia Petrillo. I love me some Golden Girls. And of them all, I love me some Sophia. Because every time she says, picture it, Sicily, 1922, my ears perk up, my eyes get big, I'm leaning into the TV because I want to know what she's going to say. Because she never disappoints me when it comes to the stories that she tells, because they are engaging. And when you think about it, stories are how humans explain the world to other humans. We convey our hopes and our desires, our fears, our dreams, our beliefs, our cultures, and our history. We do that all through stories. And we've done that for as long as humans have gathered around campfires and lived in social orders. Stories and the feelings that they invoke are deeply embedded in our DNA, just as much so as the whole concept or fight or flight. So when we think about stories, there are our experiences. They are our daily experiences of how we navigate the world, how we navigate interactions with each other, how we navigate things that don't quite make sense to us. Our complex social world is approximated by our brains telling them stories to make things seem reasonable when they initially do not. When you think about the human brain is predisposed to think about things, to make sense of things, to create things, and to create meaning from the stories that it hears. So because we view our past experiences and lives in story terms, viewing new experiences in story form seems natural to us. It's a comfort place for us. And so we have to think about in trial, especially in opening statements, how do we get the jury into a natural, comfortable place that lends themselves to believing our story over the government story? How do we get them to a place where they are empowered, inspired to do what we ask them to do? Storytelling and the stories that we tell, if they're properly told and properly constructed, they have the impact of making the jurors feel what we want them to feel. So do we want them to feel angry? Do we want them to feel sad? Do we want them to be aggravated, frightened, sympathetic? What do we want them to feel when we are developing our opening statements? And how do we craft a story to invoke that emotion? A good storyteller never abandons these critical questions when thinking about the narrative that they're going to be presenting to the jury. Can you craft an opening narrative that inspires your jury to act? Can you tell a story that empowers your jury to act? And you're probably asking, why does any of this storytelling stuff matter? I have the facts, I have the law, I go in there, I tell them what it is, and they listen, and hopefully they come out my way. But the reason storytelling matters is because let's talk about what happens when you do not tell a story in your opening statement. The first thing that happens is that the jurors will miss the message that you're trying to convey. You spent so much time diligently crafting your theory of the case, thinking through all of the bad facts, thinking through how you're going to mitigate those, thinking through all the good facts and how you're going to accentuate those. But when you don't tell a story, when you fail to put them in story form, the jury will likely miss the message that you're trying to convey in that narrative. And so we have to be able to craft a story that gets across to the jury exactly why they're here and what you want from them because they are here. When you don't tell a story, it also creates more mental work for the jury in order to support your position. We want to make things easy on our jurors. The only hard thing for a juror should be voting to convict. Everything else should be easy. And we want to do whatever we can to make it easy for them. And one way to make it easy for them is to do things that they can relate to, do things that they can sort of grasp hold on. And the way that we do that is to tell them a story, because like we said earlier, their brains are predisposed to think about the things that we are asking them to think about in story form already. And so if we don't give it to them, they'll do it themselves. When you don't tell a story, you open the door to the jurors' negative biases. So we all have biases, whether they're explicit or implicit, whether they're conscious or unconscious, whether they're intentional or unintentional. We all have them, myself included. And so when you don't tell a story that sort of addresses some of the biases that you will know that your jurors have, you give them carte blanche to lean into those biases when they are deliberating your client's fate. Finally, we're just talking about this. You allow the jurors to create their own story when you don't tell one of your own. And that story may be very different than what you want them to know and what you want them to take away from the evidence that is going to be presented in this case. And so when you're opening, that is your moment to take the reins from the government and paint the picture in the light most favorable to your client, where the government then has to play catch up for the rest of the trial. But they're constantly going to be trying to get back on the other side of this thing. And the thing to keep in mind is that jurors are not supposed to start with a neutral base. Jurors come in with a presumption of innocence. They come in presuming your client is innocent and saying, government, you must convince me otherwise, to the sufficient standard by which you are held to. Because if you do not, I have to go with the presumption I came in. So never let them tell you, never let the government or the judge tell you that the jurors come in neutral. That's not what the law says. The jurors do not come in neutral. And the story that we tell has to be one that doesn't acknowledge or doesn't give credence to the neutrality of the jury, because they come in on your side, as they should. And our stories should lean into that.
We have a question.
Absolutely, yes, sorry, I'm talking, go ahead.
Do we want to tell our story after the government's opening, or is it better to wait for the government to rest its case?
That's a great question. My belief, and I'm going to give you my belief because nothing I say is hard and fast and written in stone. We never waive our openings or never reserve opening until the government closes their case in chief. And here's why. We want to take the first opportunity possible to skew the perceptions of the jurors. And that first opportunity is literally right after the government opens in their case. So we don't want to go through all of the witnesses and then get up and say, all right, now let me tell you what's really going down. We want to start at the very beginning, because now everything that the jurors hear in the government's case in chief can be colored by what you say in your opening. And you lose that ability if you reserve opening until after the government rests. Any other questions for now? Remember, you can ask questions at all times. I love questions. And I hope that answered your question. But so now we know what happens when you don't tell a story. What happens when you do tell a story? It's story time. So when you tell a story that is effective in opening statements, the first thing that happens is that your message bypasses the jury's own storytelling filter. And so we talked about that just a second ago, where if you don't tell them a story, they'll tell their own. And so when you tell them a story, now they're so consumed with the brilliant storytelling that you just gave them that they don't have time to craft their own story or filter your story version of events through their own storytelling filter. So you bypass that hurdle when you tell an effective story in and of yourself. Secondly, your story couples you with the jury. And what I mean by that is if you're telling an effective story where you're painting a word picture, and we'll talk about word pictures in a second, but when you're telling that story, you begin to build a connection with the jury. You begin to build an experience that you and the jury can walk through together. And you want to be seen as the most persuasive person in the courtroom. You want to be perceived as the most reasonable person in the courtroom. And quite frankly, you want to be perceived as the most likable person in the courtroom. And part of building those things is telling a story that the jury can follow along with you, feel like they're transported to a different time and space, and empathize with what you're asking and what your client's plight ultimately is. And so those stories help you couple those things together in a way that the government usually doesn't have the ability to do. Because if you think about it, the government has a lot of formulaic rules that they have to follow in order to make things work for their favor. They have to get out certain elements and they have to say certain things. Otherwise, they subject themselves to certain rulings and orders. And so because of that, they follow a script more often than not. And that is sort of their Achilles heel, is that they have to follow that script. That is a script that we don't necessarily have to follow. As long as we're staying within the framework of what an opening statement is, we have a lot more leeway to say the things that we need to say in order to benefit our client.
Okay, we have another question.
Mhm.
How do you connect voir dire of panel with opening?
Yeah, that's a great question. So the way that I do it is I try to get out pieces of my theory of the case in voir dire to the extent that I can get the judge to agree to ask certain questions that sort of get out little hints of what my theory is. I've started to plant seeds in the juror's mind. And so then when I'm incorporating my theory and my theme into my opening, I've already sort of prepped and primed the jury in voir dire to hear what I have to say in opening statements. And so it's just a matter of crafting the right types of voir dire questions with your theory in mind. You're going to hear me say this at some point, and I should say it now because it's so important. Theory is everything. Everything we do in our trials is theory driven and theory centric, all the way down to the questions we ask in voir dire. And so when you're streamlining and incorporating your theory and theme into the voir dire questions, you're starting that work of connecting all of the pieces of your trial presentation together. And so I do that. The first thing I do whenever I think about my case, I look at the facts, I go through the discovery that I have, but then I start thinking about what is my running theory of the case. I may write it out first, and then I'm constantly editing it and changing it as I'm going through the facts over and over again. And then when I have a theory of the case that I'm solid with, one that I like, one that I think this is going to work, then I start asking myself, all right, based on this theory of the case, what questions do I need to ask in voir dire? What questions do I need to present to the judge, if you have to present them to the judge, to get approval for it to ask the jurors or the prospective jurors in this case? And I'm thinking about, okay, this is my theory. What story am I telling? Because once I figure out what story I'm telling, it might actually help me craft the voir dire questions that I need to craft. And so it's a matter of linking those things together, linking voir dire to opening statements to cross-examination to closing, and having it all be consistent. Because that's the one thing that I think sometimes lawyers, we get caught up with, especially criminal defense lawyers. We lose a little bit of consistency when things may not go our way, and we get panicked and we think we have to switch or change something. When in fact, if we just stay the course a little bit, we'll find that we're in a much better place, in a much better position. But the last, go ahead. Yeah.
Sorry, we have one more question building on that. Does the government's opening ever alter the opening you then give? And how do you adjust on the fly if need be?
So the government's opening never alters my theory, which means it never really drastically alters my opening statement. And here's why. Because when I'm thinking about my theory, part of what you think about when you're crafting your theory is anticipating what the government is going to say. And it actually is a pretty easy exercise to do because the government, again, is fairly formulaic and fairly ritualistic and procedural. And so it doesn't become that difficult to sort of think through what the government's opening is going to be. You know the basic facts. You know the non-basic facts. You know the advanced facts. By the time you got to trial, you have digested and gone over these facts so much that you probably have them down packed in your head. So you know every fact the government is going to say. And if they come up with a fact that is outside the realm of like possibility or something that you ain't never heard of before, then you probably need to ask the judge for a sidebar to be like, this was not disclosed to us pre-trial. And there may be a discovery issue there. But for the most part, you're going to know everything that the government is going to be saying, especially in our cases, where they pretty much telegraph most of what they're going to do in most of the cases that I've ever tried. And so it doesn't drastically alter. There might be 1 or 2 points that I want to add or incorporate into my closing, but it doesn't make a significant drastic change to what I'm already going to say. All right, so let's talk about the mechanics of a storytelling, like of a storyteller of a story. So let me ask you, just basic, very basic, when you think of a good story, what do you think a story should have? A good story, a story that keeps you engaged. What do you think it should have? Any answers at all?
A main idea, conflict, easy to understand and follow.
Yep, yep. All of those are absolutely spot on, and we're going to get into just about all of those.
Resolution.
Mm-hmm. Yeah, you can break those. Oh yeah, what was that, Jenny?
A main character.
Yes, 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 and more yes to all of those. So we can break that down to even a more simplistic, fundamental foundation. A good story has a beginning, a middle, and an end. And trust me, nobody ever gets the answer right because it is so basic. But these basic tenets and principles of a story are the bedrocks, the building blocks of such effective storytelling. And each one of these things fulfills a very distinct purpose. And so getting to some of the things that you all mentioned have to be in a story, let's talk about the beginning of your story. Here, the beginning is your goal is to hook your reader. And in this case, the readers are jurors, right? So our goal is to hook the jurors by introducing the main characters. What are their goals? What are their motives? Do they have biases? What are those biases? Are they connected to their relationship with other characters? The beginning is also where you set the mood and the tone of your story. Are you looking to be agonizing? Are you looking to be frightening? Are you looking to be frustrated? So you set the tone and the mood during the beginning. Now the tensions can fluctuate, but the mood and tone should stay consistent. So whatever you're trying to convey should be consistent when you introduce it in the beginning. It should be consistent throughout the middle of your story, and it should be consistent even at the ending of your story. Now, the middle of your story, this is where the meat of your story is, right? This is the gritty part of your story. This is where you have that series of events or complications. You're leading to an increase in the tension or the character arcs. You're also exploring how characters change and they grow and they deal with conflicts. How do they interact with each other? How do those interactions lead us to where we are, which is this trial? And so you might resolve some minor conflicts, but this is where you start to ratchet up the conflicts and the climax. And then finally, you have the ending of your story. This is where your main conflict is resolved. You tie up your loose ends, the tension falls, the feelings are good at this point. And you leave the jurors feeling satisfied. And here's the point that matters. When you leave the jurors feeling satisfied, I'm not saying satisfied as in happy. I'm saying satisfied as in, even if they don't like the way things turned out, i.e. they want to convict, but they really can't, they are satisfied knowing that a resolution took place. So you never want to leave it open-ended. So your story is always going to end with an appeal to the jury to do something that will satisfy them. And hopefully that will be to acquit your client. Now, once we started to think about the beginning, the middle, and the ending of our narrative, of our story, then we have to ask ourselves what I call the 5W questions. And this sort of image represents what we were just talking about on the last page. So your exposition is your beginning of your story. That's where you're introducing everything. And then you have this rising tension. That's going to be the first half of your middle. Your middle is going to ultimately climax with that sort of inflection point. And then the second half of your middle is going to be the falling action. And finally, your ending will be the resolution. Now, here's what's important to know before we get into the 5W questions. The government always wants to make the climax the pinnacle of this upside down image. Your job in crafting your story is to determine, one, whether that is where you want to have the climax, and two, if it's not where you want to have the climax, then where does your climax fall? So for example, in a murder case, the government is always going to want the climax to be the death of the decedent. That's always going to be where they put the climax. You're going to hear la, rah, 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 and he died, or rah, 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 and defendant murdered him. That's always going to be the climax. But you have to ask yourself, is that the climax of your story? And the answer probably is no. The answer probably is you don't want the climax to be where the government's climax is, because if it is, they win and you lose. And so take, for instance, a domestic partnership murder, where a domestic partner takes the life of their spouse. The government obviously is going to make the climax where the spouse loses their life. But maybe the climax for you is before the loss of life, where the abusive spouse threatens to kill your client. And after years of physical, verbal, and mental abuse, your client actually genuinely believes that the decedent would kill her the next time. And so your climax is actually at the threat from the decedent, not the loss of life. And you need to figure out how to craft a story around your climax and not allow the government to set the inflection point. So we're thinking about the 5W questions. The first question is who? Who are your protagonists? And how might they grow or diminish to create the tension in your narrative? Who are your antagonists? And how will their development impact the narrative that you're trying to tell? Who in your cast of characters do you want the jury to sympathize with? And the answer probably is your client. But maybe it's not. But you have to think about who you want the jurors to sympathize with, who you want them to empathize with. Is there an empathy but lack of sympathy issue here? And what you see, and when I say that a lot in the context of sex assault cases, where, for instance, maybe the complainant made up the version of sexual assault because they didn't want their parents to find out that they were having consensual sex before marriage. So, and maybe their parents are super strict and super religious. And so you empathize with it, you understand them, but you can't sympathize with them trying to send somebody to jail for something they did not do. So you have to think about those who questions. And then the next thing you want to think about is the what question. What motivates your characters? And how might those motivations be challenged in the context of your story? What impact might, for instance, misguided motivations have on why your client is sitting in this courtroom today? So we always want to think of the what question. More basically, we want to contemplate the where question as well. Where does your story take place? What's the setting? Does that setting impact the major theory that you're trying to advance? And if it does, how do you deal with that? We then ask ourselves when does this stuff take place? When does the story take place? What's the timeline? And when might your readers least likely to expect some tension or some surprise to occur? And that's just good storytelling. You throw out a thing that's jarring or surprising when the jurors least expect it. And they're like, "Ooh, I didn't expect that." It also helps control your jurors so that they're actually listening to you. And it helps diminish the amount of times that they're just wandering off into la la land in space. And then finally, we ask ourselves, why? And this might be the most important question that we ask ourselves and we contemplate when we're thinking through our story. Why should the jurors care? Why should they be emotionally invested in the story you're trying to tell? Why should they feel empowered, inspired to act on your client's behalf? If we can't answer the why questions, then the first 4 questions don't matter. So now that we sort of thought about the sort of mechanics, the first part of the mechanics, we have to think about learning styles and memorizational styles of our jurors. Research has told us that there's 3 basic types of learners in our society. We have our auditory learners, our visual learners, and our kinesthetic learners. Auditory and visual, we know what those are. Auditory learners, they learn best by hearing, learn best by audibly hearing what the instructions are. Visual learners learn best by seeing. Kinesthetic learners learn best by doing. They're tactile in their learning process. And so the question we have to ask ourselves, one of the questions or the many questions we have to ask ourselves when we're thinking about how to craft our story is how do we appeal to as many different learning types as possible? How do we incorporate as many different learning types as possible? You may not be able to incorporate all three into your opening, but you should be able to incorporate at least two. And so how do you incorporate them in a way that's effective, in a way that is not mundane or boring, in a way that engages your jury and that, again, empowers and inspires them to act on your behalf? And so part of that might mean you might want to do something with visual aids, like a PowerPoint or a video or something like that. For kinesthetic learners, you might have a prop that you get pre-approved by the court, of course. You don't want to come in with a prop that's not pre-approved, but you might want to get it pre-approved and let the jury feel and touch that prop as you're talking, especially for kinesthetic learners. So for instance, if you're in a gun case, and the guns are usually deactivated by court staff before they come into the courtroom anyway. And so it's going to be brought into evidence. So maybe you want to use the gun as a prop or demonstrative in your opening. When you're saying there's no way my client could have run at the speed that he was running at with this gun in this waistband, considering he had on pants that were 5 times too big and no belt, and this gun would not have stayed in place. And as you're saying this, the jurors are touching this gun and looking at this gun and feeling this gun and holding it and seeing that this gun is very, very heavy and that it would not have stayed in place. For kinesthetic learners, that is valuable moments for them to engage and connect with your story. And so we're always trying to figure out how to diversify the presentation to incorporate as many learners as possible. The next thing we want to think about is where we place things in our story. Where do we place certain people? Where do we place certain moments in time? Where do we place certain bits of information? And the reason we have to contemplate placement is because of this thing called primacy and recency. And so when you think about in persuasive communication, then we take this a lot from marketing, but the order of information being presented has a significant impact on how people will receive that information. Information presented to people first tends to be the information that they find most meaningful, or they place the most meaningful marker on, which means they tend to remember it more vividly than things that things that come after it. That's the primacy effect. Things that people hear first tend to be things that they remember more solidified. Then you have the recency effect. So if we think about how people remember things, primacy is 1A, recency is going to be 1B. Because recency is the same thing. Things that people hear last tend to be given significant meaning as well. And things in the middle are sort of muddled and they get lost and things like that. And the reason this matters and works is because the way our brains work. So when you think about your brain's semantic memory, right? Your brain's semantic memory is where things are most stored. And so when your brain gets things that come in first, it tends to recognize those things as meaningful and important and things that they may not want to displace. But when things come in after that, it's constantly going through a process of sorting and displacing those things to make capacity for things that come in later. And then when it comes to the end, when you hear those things and your brain recognizes that nothing else is coming in on this topic, it stops the process of displacement. And so now the things that are most prominently pointed in that department of your semantic memory are the things that heard first because it did not displace those, and the things that heard last because it did not displace those. And so the things you really want the jurors to remember and hear, you want to find ways to place those either at the beginning of your narrative or at the ending of your narrative. Or find ways to reset in the middle by jarring them back to wait so that they can focus on what you're saying. So now that we've sort of talked about the varied styles of learning, why we place things where we are, there are some elemental mechanics to storytelling that I want to go with you very quickly. The first thing is that your story must have purpose and or value for the jury. This gets to that why question. Why are we here? Why does this matter? You have to give them the purpose or value through your storytelling to help them understand why they're sitting here when they could be doing other things with their life. Your story needs to be about characters in pursuit of goals. And those goals don't need to be positive goals. Sometimes the goals is to screw your client. Sometimes the goals is to win at all costs. But you need to be able to flesh out who these characters are and what their goals are and how they are pursuing them. In that same vein, we also have to think about the challenges that these characters must overcome. Again, this doesn't always have to be a feel-good story. Oh my God, they overcame challenges. This is so amazing. Sometimes the challenges is how do they overcome the lies that they told? How do they overcome the misrepresentations that they made? That could be the challenge that this particular character is battling at this moment. And so we always have to think about what that challenge is going to be and how that interplays with the character and how that sort of interconnects with the other characters of your story. And then finally, your story must be told with descriptive details. And what I mean by descriptive details is I want to talk to you about painting a word picture, transporting your jurors from the jury box to an actual moment in time of your version of events. Because it's one thing to just tell them what happened and to recite what was going on, but it's a completely different thing if you use your words and your presentation to really transport them to a different place in time. And so we're going to talk about each one of these in turn. Let's start with your purpose or value. And this is what I consider the place where we talk about theme and theory. So firstly, let's talk about theme. Your theme is literally that catchy thing that you're going to say that's going to permeate your entire trial presentation. So, for instance, no good deed goes unpunished. That could be your theme. That could be the theme of your entire trial. No good deed goes unpunished. Or a bird in the hand is worth more than two in the bush. That could be your thing. Whatever your theme is, whatever that catchy thing is that a juror can quickly identify with, that a juror can quickly latch onto, that won't be easily forgotten. And that will permeate every aspect of your trial presentation. And you start that in your opening statement. Next, we talk about theory. And you're like, what's the point? What's the point of all of this? What's the point of talking about theory? Well, the point is that theory is everything. And I said this earlier, theory really is everything to what we do in trial. And so how do I present theory when I'm talking about it? And the best way I found to do it is the three-legged stool. This is the three-legged stool theory of the case stool. And so what does this three-legged stool, how is it held up? How is the theory of the case held up in our trials? Well, one, the first leg are the factual component of our theory. And this is where we bust our facts and we figure out what our good facts are, we figure out what our bad facts are, we figure out how we can evidence block the bad facts and maybe get those excluded. And then we think through what our theory of admissibility is for our good facts. And so that's the first leg of our theory. The second leg of our theory is the emotional component. What emotion are we trying to convey? Do we want the jury to be angry when we're done talking? Do we want them to be sad? Do we want them to be motivated? Do we want them to be inspired? Do we want them to be frustrated? What emotion are we trying to convey to the jury in our story? And then finally, how do those two things connect to our legal component? What is the legal component? Is it self-defense? Is it mis-ID? Is it actual innocence? Is it consent? What is the legal component of this legged stool that allows it to be held up? And the reason I chose the three-legged stool is because what you'll realize is that if I cut one of these legs off, this stool cannot stand. And it's the same thing with your theory of the case. If you cut one of these components out of your theory will never hold up under even the slightest amount of scrutiny. And so I was trying to figure out what is a very concise way to just give you a definition for theory. So here's my definition of a theory of the case. Your theory of the case is the factual and emotional narrative about the people, places, and plot that is consistent with an available legal defense and that explains the client's innocence, reduced culpability, or non-guilt. And the non-guilty is in quotation marks because we all know that guilty and not guilty are terms of art, and so I always put it in quotation marks. But that is in essence, in a nutshell, the theory of the case. So if you don't remember anything, remember that facts, emotions, and the law make up your theory. And because theory is everything, that is going to be the crux of the storytelling development tool that you're going to use. So thinking about the purpose and the value as we think about theme and theory, what are some of the pointers that we think about when we're thinking about crafting our theme and theory? First, when you stand up to deliver your opening statement, there's only one purpose the jury cares about. Answer the question, why are we here? And again, the why question is so important because if they can't connect to the why, they will never connect to your client's innocence. So always answer the question in your opening statement, in your opening story, why are we here? Your theme, if introduced early, i.e. in opening statements, gives them a clear taste of sort of the bigger story, and it conveys that purpose from the onset. So if you think about this particular theme, shame, sadness, and sympathy, that's your triple, that's your theme, that's why we're here today. And you're gonna tell a story that involves shame, sadness, and sympathy. And you're gonna talk about how your characters interplay with those three things. And so you set the scene with the shame, sadness, and sympathy, but then you bring in your story to convey the shame, the sadness, and the sympathy. So for instance, and I won't use this, but I'll give you sort of an intro into an opening. Ladies and gentlemen, I want you to think about 1941. And I want you to walk back to that date and time with me. It's January 10th, 1941, in the subways of London. The lights are dim. The air is thick. The people are crowded together. The tension is palpable. They're asking themselves, have I done enough? Did I say everything I needed to say? Did I do everything I needed to do? Was I the best version of myself during the life that I've lived? You can hear the cries of children in the background. You hear the wailing of the elderly. And then in the corner, in the distance, you see Mr. Doe. He's curled up in a ball, tears streaming from his face. And he's just saying, I didn't want to do it. I didn't want to do it. You're wondering, what does he mean when he says, I didn't want to do it? And then you realize that Mr. Doe has just done one of the most difficult things that he could ever do. He saved his own life. But the saving of Mr. Doe's life came at the expense of the loss of life of Mr. Marinelli. So now I've set the scene. I've set up the scene. I've sort of introduced some characters. You got Mr. Doe, you got Mr. Marinelli, you got these people all in this subway. And I'm setting up the scene because I want to hook people in to what this opening is about to be. And again, I'm using the facts. I'm not going in there talking about speculations about what people thought. I'm using the facts of what I know about this case. I know what people were saying because I have interviews with them, or I have witness statements, or I have things that I can prove this up in the trial. And I'm using it, but I'm also being very intentional with my language. I'm being very intentional with the placement of what I say, because I understand that this is a story that needs to be engaging. And so I need to be able to introduce from the outset what my theme is and the intro for this story that I'm about to tell. I think, do we have a question?
Yes. Will the slides be made available? And the answer is yes. The recording of this presentation, as well as the slides, will be posted to the IDC website.
Awesome. So we're thinking about theme, and now we're thinking about repeating the theme. And
One more question, sorry.
Oh yeah, go ahead.
Okay, you just said that's your triple. Maybe I missed it, but what exactly, what do you mean by that?
Yes, I'm sorry. So a triple is something that we take out of marketing. And what we mean by triple is that marketers tell us that people tend to remember things in threes. And so if you say things in groups of threes, you tend to have a better chance of having your jurors remember what that thing was. So if your triple was shame, sadness, and sympathy, it's much more likely that the jury will actually remember shame, sadness, and sympathy before they remember just shame, just sadness, or just sympathy, or some duo of that three. And so marketers tell us if we're going to say things like that, we want to say them in groups of threes. And it doesn't always have to be alliterative either. So it doesn't have to be S's or T's or P's or whatever. It can be my client didn't possess the gun, he didn't have the gun, my client is not in it, my client is not guilty. Or my client didn't rob anybody, my client didn't have a gun, my client is innocent. But you say it in a group of three, and that way the jurors are more apt to remember it. So what we also think about when we're thinking about theme and theory is the repetition of your theme. So there's something to be said about grouping things into three, but there's also something to be said about just repeating things so that a juror will remember them, embrace them, and apply them to whatever they see during trial. And there was a triple right there: remember, embrace, and apply. I did that one unconsciously. So that's an ideal, that's an example of a triple. They'll remember it, they'll embrace it, and they'll apply it. So that's what we're talking about when we're thinking about the purpose or the value and how that relates to your theme and theory. But what about your character? So we talked about the second elemental mechanic being your character development. This is perhaps one of the greatest characters in cinematic history. Hannibal Lecter, they did so much with his development that it kept you engaged, it kept you intrigued, it kept you interested in what he was doing. And the beauty of what they did with Hannibal Lecter is they didn't make him all bad. They didn't make him all good. They didn't make him all evil, and they didn't make him all saint. They made him complicated. And his complications is what kept us entertained. And so when you're thinking about your witnesses, you're thinking about your cast of characters, obviously we don't want to say things that are wrong, and we don't want to say things that misrepresent who they are. But to the extent that you have an idea of who they are, what their motivations are, what their biases are, we take those things and we figure out how do we make them interesting, intriguing, unique, something that will catch the jurors' attention. And we may want the jurors to be like, these are awful people. We can figure out how to do something interesting to make that happen. If we want the jurors to think, oh my God, I so sympathize with them, I just want to give them a big hug and tell them things are okay, we could do that in an interesting, intriguing, unique way. And so we're always thinking about those three things: interest, intrigue, and uniqueness when we're talking about character development. Also, what are our goals with these characters? What do we want the jurors to know about these characters and their goals and their motivations? What are their motives? Why are they doing what they're doing? Why is this witness saying that they saw your client if they really didn't? Why is the government railroading your client by having all these insane charges that don't fit the facts? Why is the police officer coming in here and saying that they did certain things that they did not do? What are the motives behind why the witnesses and cast of characters are saying and doing what they are doing? Who are your climax character? And I gave you the hint, it's the jury. The jury is your climax character because the climax character is who resolves the conflict. And you want your jurors to be put in that position to solve the conflict. And you want them to be put in the position to solve the conflict in a way that benefits your client. Now, what about the challenges or conflict? Because we talked about the purpose and value. We talked about the characters, but then that third prong was that those characters have to have challenges or conflicts. So the first thing is, what's the critical scenes? Again, your critical scenes may not be the government's critical scenes. So you need to identify the critical scenes for you. These are the moments that change the atmosphere, that change the environment, that changes the narrative. And so what are those scenes? What's the risk and dangers? What are they? People pay much more attention to risk and dangers and controversies than they do to when everybody's kumbaya. When everything is happy and nice and peaceful, ain't nobody paying attention because it's not entertaining, it's not interesting. So what's the risk and dangers in your story? What are your character interactions? How are your characters interacting with each other? And how do those interactions change and progress and maybe advance your theory? The state actors in actions. How does the state play involved in this? Police officers, prosecutors, probation officers, if that's the case. How do they all play a part in the story that you're telling? And then finally, what's your conflict resolution? What are you asking your climax character to resolve? And how are you asking them to resolve it? Finally, we're talking about descriptive detail. Paint your word picture. And you're probably asking, what in the world is a word picture? Well, I tried to find an example of it, and this is the closest thing I got to it, but it actually works out fairly well. A word picture is a time and place where you transport your jurors back to. And so you have to think about how you're going to do that and not just have them sitting listening to a recitation of events. And the way we do that is starting by thinking about our word choice. What words are we using? So there's one thing to say that it was an awful experience, but it's a different thing to say that it was a bloody, violent, torturous experience. Awful is okay. Bloody, violent, and torturous is better. And it's more descriptive. It's more engaging. So you always want to think about your word choice. You also want to think about your sentence sequence. Where do sentences go within the context of a paragraph? Because if the sentence goes in the wrong spot, it could diminish the integrity of the story that you spent so much time crafting. Verb tense. Verb tense is very important. And you're going to hear certain jurists, certain lawyers say certain things. Here's my take on verb tense. In an opening statement, your verb tense should always be present tense. You should rarely be using past tense in your opening statement. And here's an example why. If you say he went to the store got robbed, he got shot, and he died. That's factually accurate. What if you say, Mr. Doe is at the store. He's shopping for dinner to feed his family. As Mr. Doe comes down the aisle of the pasta section, he hears a loud bang. Pop! Mr. Doe, startled. He doesn't know what's happening. But his natural instinct is to drop to the ground. Unfortunately for Mr. Doe, he doesn't do it in enough time to save his life. The robber, who is ransacking this store at the moment, notices Mr. Doe. He starts walking towards Mr. Doe. Mr. Doe is on the ground, shaking, trembling in fear, not knowing where the next hour of his life is going to be, if he's even going to have a next hour of his life. And then at that very moment, the doors swing open and rescue come and blah, blah, blah. But you see, the present tense is transporting your jurors back to that time. The present tense is putting the jurors in the space of Mr. Doe. And so especially if you have them close their eyes while they're doing this, they're visualizing this as you're speaking. And it's so much easier to visualize it if you're speaking in the present tense than if you're speaking in the past tense. So always remember your verb tense. And then what about your narrative chronology? This is the moment where you're thinking about, where do I place certain pieces? We were talking about primacy and recency. Where does this part of my story go in the grand scheme of my narrative? Where does this part go in the grand scheme? How do I make it so that I'm saying the most important things at the times when the juries are listening the most? And then finally, your use of demonstratives. We talked about learning styles. We talked about the different types of learners. So what demonstratives can you use to vary the number of styles that you are appealing to? And your own body could be that, for example. Maybe you are somebody who paces. Maybe you have intentional movements. Maybe you talk with your hands, so we need to figure out how to be more intentional about it. But these are all the things that help you with creating that word picture that's so important to storytelling. And it helps you evoke that emotion as well. And I'm going to keep talking about emotion because I believe that emotion is the most important tool in our toolbox of storytelling. And I have somebody who's pretty famous who agrees with me. Maya Angelou once said, I've learned that people will forget what you said, people will forget what you did, but they will never forget how you made them feel. And so when we're telling stories, we need to always think about the feelings. because they can't quite remember all of the narrative events in terms of facts. They will definitely remember the feelings. And if you can remember all of this, you always remember that you got this. Thank you for listening.
Great, thank you very much for that presentation. That was excellent. We're going to open it up for questions. If anybody would like to type in the Q&A or the chat where I can unmute. Let's see, it looks like we have one question here. Do you think it's better an opening to say to the jury at the end, that is why client is innocent, or that is why you must find client not guilty?
Yeah, no, so I think it's such an interesting or fascinating question, because I always, as much as I can, open on innocence. And so I'm constantly talking about my client's innocence, but I also recognize that they have to make a verdict. They have to find him either guilty or not guilty. That is what the verdict is going to be. And so I always ask them at the end to render a verdict of not guilty, because they're not rendering a verdict of innocence, but they should render their verdict of not guilty because my client is innocent. So I spend a lot of time building up the innocence narrative, only to then ask them to do what everybody else is going to ask them to do, which is to find client not guilty.
Any other questions? Okay, here we go. Do you have an approach for the case where the evidence is overwhelming? Say offenses on video pretty clearly, and the jury may be wondering, why are we here? How do you begin to come up with an opening to change the story?
Yeah, so this is where we have to sort of use our creative innovation a little bit. So for instance, I had a case where pretty much client confessed on camera to police officers at the station after being Mirandized. So I had no pre-trial litigation motions whatsoever. But what I was able to do is I watched that confession so many times, to the point where I started picking up little tiny subtle hints that maybe he might have been coerced and manipulated into confessing. And that was the only play that I had. And so I leaned into that, and I got experts, and I had them watch the confession and analyze it and tell me all the ways in which officers manipulate and coerce confessions out of people. And then I used all of that to craft my narrative or version of events. And so even though there was confession on tape that was legally valid, I was able to at least get one juror to believe that client's confession was coerced. And once I got that, we hung it. Now we got retried, it hung again, and the government ultimately decided not to retry the case. And so client walked. But that was just a matter of me just sitting with the bad facts and crying and shedding as many tears as I could, until I found that one minuscule thing that I could like latch onto like a bulldog and not let go.
Okay, how do you balance versus prosecution's opening, i.e. conflicts of fact, interpretation?
Yeah, so my facts are always the facts that I believe are the facts. I don't ever buy the government's facts if they're contrary to mine, because I believe that in order for me to make a jury believe it, I have to believe it too. And if I'm saying something that's contrary to what the government is saying, but I'm gonna like, the government might be right, but I'm just gonna say it because I got to for client's purposes, it ain't never gonna work. And so I always believe if I'm going into trial with a set of facts, there are facts that I believe I can prove up. There are facts that I believe I can get out through witnesses or other evidence. And there are facts that even if the government disagrees with them, we'll just fight this out in closing or somewhere else. But I'm not going to change my facts just because the government says something else happened. So for instance, the government comes in and is like, well, this happened over here on XYZ date. And I'm like, no, it actually happened on the other corner and it was the day before. Like, we may have two opposite witnesses who say two different things. I'm going to credit my witness because my witness advances my theory of the case. The government's witness doesn't, and so I'm going to find ways to discredit theirs, but I'm never going to somehow transition my belief of the facts into theirs.
Okay, any other questions? Oh, we have a hand. From Stephanie.
Hi, Stephanie. I think Stephanie might be muted.
Yep. Stephanie, can you unmute? There you go.
Okay, thank you. My question is, if you're not in trial, you can use you use all of these techniques and storytelling, or is it only for trial with a jury? I mean, do you use the same theories and the same set of your same procedurals for
Yeah.
like a bench trial or for a sentencing? Can you use the storytelling for things other than a jury trial? Thank you, and you were awesome.
Well, thank you, Stephanie. And that's a great question. That's actually a fantastic question. And the answer is yes, these skills are transferable. So like when I'm in sentencing, I come up with an opening statement for sentencing, especially if I'm allocuting in a really bad sentencing where the facts are awful. I come up with my theory of sentencing. What is my theory to minimize my client's exposure once we've gotten past the guilt phase? And so I think about what's going to appeal to that judge. How do I craft a narrative that lets the judge like, yeah, I'm gonna go give him the low end, or I'm gonna downward depart or downward vary. So I definitely do it for sentencing. I even technically do it for my oral arguments in appellate court. So when I'm going before the 11th Circuit, I'm thinking through, okay, this is a legal argument, yes, but there's a human being behind this legal argument. There is a life at stake. And so what narrative am I giving to the jurists who are making this decision that combines the law with the facts in a way that is super persuasive? And I start that when I'm filing my briefs, when I'm crafting my briefs for appeals, because you have your fact section. Your fact section doesn't need to be sterile. And I think that's the biggest misconception with appeals, is that you just put the facts out there as they are. On this day this happened, on this day this happened, and then this happened, and then this happened. Give me a story. And I can tell you appellate judges love reading those stories. I've had appellate judges say, your fact section was really, really brilliant. Whether they agree with my actual legal analysis or not, they were able to at least engage with my fact section. And so I think these skills are definitely transferable.
Okay. Anyone else? Any other questions before we conclude?
Awesome.
Okay, looks like that's everything. So thank you again, Mr. Conway. Thank you to all the attendees. Again, the recording of this presentation along with the slides will be on IDC's website. See, our next CLE will be on March 24th at noon. It'll be by Monica Mayo, and she'll be discussing how to challenge the principal actor element of the new juvenile transfer statute. So we hope to see you all there. Again, thank you, everyone.
Bye.